this meeting. It is held virtually via Microsoft Teams. We'll then proceed. I also want to take this moment to welcome the members of the public that are following us through the various live streaming platforms. My name is Muzu Vugile Mkize, Muzi for short. I'm the full-time regulator member primarily responsible for the petroleum pipelines regulation. I will be chairing this meeting of today, and with me today are the members of the PPS, which I'm going to shortly introduce. I have Madam Pungose, who is the Deputy Chairperson of NERSA, as well as the Chairperson of the HRRC, which is the Human Resources and Remuneration Committee, and serves at various committees within NERSA, as well as being the member of this committee. Madam Pungose.
Good morning, Chairperson. Good morning, members of the Energy Regulator, and greetings to members of the public who are live streaming. Thank you.
Thank you very much, Madam Pungose. I also have got Madam CEO, who is the CEO of NERSA, Advocate Nomalanga Sithole, who is also chairing the Regulator Executive Committee, serving at various committees of NERSA, and is a member of this committee. Madam CEO.
Good morning, Chairperson and members of the PPS and everyone who has joined us for this particular meeting this morning. Thank you, Chairperson.
Thank you very much, Advocate Sithole. I also have got the full-time regulator member primarily responsible for pipe gas regulation, and is also currently assisting as the acting full-time regulator member primarily responsible for electricity regulation. She chairs the subcommittees dealing with the regulation of these two sectors, as well as serve at the various committees of the energy regulator, even including this one. Madam Maseti.
Thank you, Chairperson, and good morning to you. Good morning to the members and everyone on this call, as well as the members of the public. Thank you, Chair.
Thank you very much, Madam Maseti. I'm not so sure if Mr. Fungais Banda has joined. He is a part-time regulator member and is a chair of the Information Technology Governance Committee, serves at various committees of the energy regulator, including this PPS. You'll let me, Madam Asangani, when he has been able to join, understanding that he's got some challenges in terms of connecting where he is.
Good morning, Chair. I'm here, and good morning to everyone who has joined us for this meeting. Thank you.
Thank you very much. Much appreciated, Mr. Sbanda. We appreciate the fact that you have surmounted all the challenges to join us. We've got a relatively short agenda before us, but before I get there, I would also just highlight that in the agenda that we had, there are some changes. Item 9 has been withdrawn due to the being surpassed by events of the recent events. And then we also have item 8 regarding the GIS system, as well as matter number 10, item 10, that deals with the delegation matrix revision. These are going to be discussed as part of the governance in a closed meeting. This then effectively leaves us with 3 items to discuss in the open meeting, which 3 are also for approval. Members, by show of hands, if you approve of this agenda as amended. Thank you, Madam Maseti. Thank you, Advocate Sithole. Thank you, Mr. Sbanda. Thank you, Madam Pungose. I also support. We then move to the declaration of interest. Members, if there are any interest on your side to declare, by show of hands, please. I don't see any hands. I take it that there are no matters of conflict of interest based on these agenda items to be declared. I also want to take this opportunity to implore of you to please fill in the declaration of interest forms and share them with the Secretariat, Madam Masangani. With that, let's then proceed straight away to item 5, which is a decision and reasons for decision on the multi-year tariff application by Engen Petroleum Limited for its petroleum storage facility in Island View, KwaZulu-Natal Province, for the period 1 January 2025 to 31 December 2026. Mr. Untit, as you are the acting executive manager in the stead of Madam Twa, you will be marshalling your forces in this regard, dealing with the 3 items. Over to you, sir.
Thank you, Chair. Good morning to you, members, colleagues, and members of the public. The first item will be introduced by Ms. Somi, the analyst that worked on it. I just want to then also sensitize the members that of the yellow highlighted text that should not be disclosed during posing questions and discussions. Ms. Somi, taking it as read, just highlight the key matters for the members. Thank you.
Thank you, Martin. Thank you, Chair. Good morning, members, management, and the members of the public. The purpose of the submission is to request the PPS members to approve the tariffs applied for by Engen Petroleum Limited for its petroleum storage facility in Island View, KwaZulu-Natal Province for the period of 1 January 2025 to 31 December 2026, and approve the decisions and the reasons for decision document attached here as Annexure A. It should be noted that this is not the first tariff application by Engen. However, the first tariff application after issuing of the amendment license approved on 30 August 2022. Engen's initial submission was submitted on 19 December 2024. Several engagements were held with the licensee. The submission was then declared adequate on 10 July 2025. The detailed assessment of the tariff application is provided from page 9 of the submission. NERSA determined tariffs of 24.20 cents per litre for the 2025 financial year and 24.11 cents per litre for the 2026 financial year, which are approximately 0.12% to 0.38% lower than the tariff applied for by Engen. The differences between NERSA's determination and Engen's submission are merely due to the REP values determined by both parties. The slight difference in PPE values arises from the different CPI values used by both parties in trending the assets. In determining the networking capital, Engen excluded the networking capital. In contrary, NERSA applied the tariff methodology which prescribed that trade receivables be based on 30 days of allowable revenue, operating cash and trade payables be based on 45 days of OPEX for both. The difference in work values is determined due to the difference in the cost of debt determined by both parties, and the difference in test calculation contributed to variances in the allowable revenue. It is therefore recommended that the PPS members approve the tariff applied for by Engen for its petroleum storage facility in Island View for the period of 1 January 2025 to 31 December 2026, and approve the decisions and the reasons for decisions document attached here to as Annexure A. Thank you, Chair.
Thank you very much, Madam Somi. Members, any questions, comments, or guidance to provide to the team? By show of hands, please. I don't. Advocate Tole, then Madam Maseti, followed by Mr. Sbanda. Over to you, ma'am.
Thank you, Chairperson. Chairperson, on page 4, paragraph 5.2, we are saying that the the applicant applied on December 2024. However, we rejected the application because it was not compliant with Rule 12.6. However, the application now it's for 1 January 2025 to 31 December 2026. And I was just wondering as to what happened to the tariff between 1 January 2024 to 31st December 2024. If that can be clarified, because in the text it's not indicated as to what happened. And in my reading, I thought maybe we may have skipped a year there. And the second thing, Chair, which is my last point, is that maybe for consistency in terms of numbering the versions of the methodology, we need to decide whether we use editions or we use versions. Because if you look on that page, we have those used interchangeably, and it may cause a bit of confusion. So let's try and be consistent. And the point that I'm making on the numbering of the methodology, it's on paragraph 5.1 and paragraph 5.3, Chairperson. Chair, that's all on my side, but let me also thank the presenter for the presentation. I do not have a problem with what is being recommended. Thank you, Chair.
Thank you very much, Advocate Tole. Madam Maseti.
Thank you, Chairperson. Chairperson, I'm partly covered on the first question by Advocate Sithole. However, I do want to be, I do have another part of the question with regards to the timelines. I think on paragraph 5.2, and I think also in the reasons for decision, we need to make it very clear as to what exactly is the reason for rejecting that application. It's not helpful to simply cite the rule, what the rule says, that they must submit 6 months, because sometimes they may submit 4 months and we may still be in time to actually process the application and complete it within that 4 months. So we need to perhaps put it differently, because there might be those cases, and we should be able to allow such applications and still process them within 4 months and they get approved. That is so that we avoid a situation of non-compliance and also exposing the third parties that will be affected by the tariff. So if here the reason is the lateness of the application, we should indicate that it was late and therefore did not comply with Rule 12. However, that lateness, again, we need to look at it carefully, as it is in line with the first point that I made. Because even after the rejection, the period that was then covered starts in January 2025. Now we are sitting here today in November, which is almost a year since then. There was an application in December last year, and now it had to be resubmitted. So the whole year, again, for the year 2025-26, there was no tariff, and we're almost in the end of the calendar year. So again, there is a portion which makes it worse in terms of non-compliance, with the portion that has not been covered by a tariff approved by NERSA for the whole of 2025. So what do we do in that instance? Because we have a period that covers 2024-25 that has not been complied with because there was no tariff. We also have a period covering now 2025-2026. Again, there's a part that is not complied with. And I would not want to assume just that provision of the Act that says that the previous tariff will then prevail until a new tariff is approved. But for compliance purposes and to avoid over-recovery and overcharging of customers, how do we deal with that aspect? Because it should be part of this to say that even for those periods, from the assessment and information that was requested from the applicant, it does not reveal that during these periods, the customers were overcharged or that there was undue or over-recovery during those periods. I'm asking this because, Chairperson, on page or paragraph 5.6, it states that the tariff that was applied for in respect of the financial year 2025, meaning the 2024 part that we rejected to 2025, shows an increase of 563%, which is quite excessive. Now, do we know then what happened? Because that part is not the subject of this decision that is sought today. Then what happened out there? Hence, I was saying that it would have been helpful if that information is here, so that we try and avoid the situation. And in fact, it's the period that shows from 2011 to get to 2025. And that could be explained in terms of how that happened and how we protected customers. Then the third point, Chair, is the adjustment that has been made in terms of the regulatory asset base, which appears to be the contributor to that 563% increase. Just to understand from the team, how did they look into the regulatory asset base, given the fact that in 2011 we were using a different methodology that promoted inefficiencies and using notional values, and also excluded depreciation. So that methodology obviously is the one that also caused some of the high increases. So how did we make sure that we assess and adjust the regulatory asset base such that it does not result in such huge increases that we are seeing in terms of the adjustments? Because it has jumped quite significantly. So those are the questions that I have, Chairperson, and the verification maybe that from our side, independent verification that we have done, and also maybe going forward with these figures that are so high from 2011 to get to 2025, because this licensee has not been complying in other years until now. Perhaps, and I'm not seeing something that says that we will subject these figures to the audits, even if we're accepting now, but they must be subjected to the audits in line with the RRMs, so that we can be certain that these are values that we can accept, unless then we revisited the assets, the asset register, and thoroughly checked, and also then subjected to the audits in terms of the RRM, so that we don't just accept the values that we are confronted with today. Thank you, Chair.
Thank you very much, Madam Massetti. Over to you, Mr. Sibanda.
Thank you, Chair. I'm partly covered by Ms. Massetti, but maybe just to add, Look, I guess for me, the first issue is around compliance and enforcement of our rules. Because to have a licensee, especially a major one that has not been complying since 2011, more than 10 years, I think it really speaks to our enforcement approach. But secondly, it's not too clear to me, because it appears as if we approved at some point the PE values, the increase, but I don't see an assessment of how the RAP has increased between 2011 and now. So for me, there seems to be a gap there, because I don't know what would have contributed to this massive increase in the licensee's assets. If that could be perhaps explained somehow, especially if we approved that at some point. The other issue is the increase in OPEX, which again is more than 500% between 2011 and 2025. And for me, there's another gap, in the sense that there's no explanation of, or rather an assessment of the increase in the operational expenditure. So it's not too clear to me, because inflation never increased by that much between 2011 and 2025. So I don't know what drives that increase in OPEX. So yeah, but I guess this is what you get really if you allow too much of a gap between tariffs. You then have this anomaly, and I mean it just doesn't look good optically. So I guess we just need to make sure that we enforce compliance with our rules. Thank you, Chair.
Thank you very much, Mr. Sibanda. I will leave it to the team to then respond. If you may just please respond. Yeah, and where there are comments, I think it's always good for you to indicate that those comments or that guidance, you've accepted it and you are going to implement as guided or as per the comments. Over to you, Madam Bogo, in your team.
Chairperson, and good morning to members, colleagues and the public. Chair, I'll start with the CEO's question. The question was, what happened to the 2024 tariffs then? So, members, the application was initially submitted in December of 2024. And then quickly looking at it, we noticed that by the time a decision is taken, that 2024 tariff period would have lapsed, because we were left with far less than a month to take a decision, which was not sufficient. And I have also noted the guidance by Ms. Maseti to explicitly clarify the reasons for rejecting the application. So the reason, as also indicated by the member there, was lateness and non-compliance to that rule, which requires that the application be lodged at least 6 months. And then, having considered that it was submitted in less than a month, in less than 1 month before the commencement of the period, we noted that it was impractical and impossible for the regulator to take a decision in that particular tariff period. And with regards
I think
to Yes.
Sorry, I think that what is important is just to enhance in terms of your the reasons for the rejection, to include the impossibility to effect due to the lateness, over and above just citing the rule. I think that would assist. Yeah.
Thanks, Chair. We'll do that. And then with regards to the applicable tariff, the tariff that was in place for this facility was the one that was approved in 2011. And if we look at the two tariffs, this one that is applied for, especially in respect of the 2025 financial year, is much higher, as indicated. So there were under recoveries by the licensee there. So as like the question was, what do we do then in that instance, and how do we protect customers? So what we are doing, we are required in terms of the Act to audit or verify the implementation of tariff decisions. So we will verify that the tariff that is charged for this period as well, 2024 and 2025, is not higher than the applicable tariff, being that tariff that was approved for 2011. So that is an exercise we normally do after the lapse of the period. So that will come to the members. So that's how we will protect, that's how we verify the implementation of tariffs. And in our view, they have been under recoveries from the side of Engine, which is why they were also pushing for consideration of tariffs for 2024 and 2025 as well. Coming to the issue of the REP, there's a number of things that happened there, and our licensing department will also come in to assist. Okay, let me start with the methodology. The methodology that was used in 2011 is version 2, which is not totally different from the current methodology. So there were, members, no issues of notional values being used in 2011. So the same TOC method was used. So the contribution of the methodology is not that big. What is the reason for the increase now is solely additional assets that were included in this license, especially after the repackaging of licenses, where some of the pipelines that were not part of the storage facilities were then repackaged and added as auxiliary pipelines here. There were also new pipelines that were constructed and added into this license, and therefore the regulatory asset base. So that is the main driver for the increase. And the increase in the operating expenses, in as much as there are inflationary adjustments, but it is more driven now by the operating costs that relate to the new assets included into this license, as well as the newly constructed assets. So there's the main contributor to the increase in OPEX is not inflation, but additional costs that are incurred in the operation of the other assets that were not initially part of this. What we will do, Chairperson, is to explicitly just indicate what assets were included and the costs related thereto. I hope this clarifies the matter. We also note the enhancement by CEO to standardize reference to versions of the methodology or additions. We will standardize that as well. I don't know if Mr. Untit also wants to come in to clarify the amendment that was done in 2022. Thanks.
Mr. Untit?
Yeah, Chair, I'm wearing two hats today, but in terms of then the licensing, indeed, there was 3 20-inch pipelines during the time of the MPP constructed, and that was doubling the capacity. So that was a significant cost investment. Plus, there was also a further 3 other 1.5 kilometer pipelines connecting to the berth, also to accommodate the MPP increased flow rate. So we will assist Ms. Boko to quantify this, but this is clearly stated in the amendment reasons for decision that those would have added significantly. The second aspect, I think also linking to Mr. Sibanda's question on the OPEX increase, they've also embarked on what they refer to as efficiency enhancements. Now, much of that is not necessary construction work, but more small optimization projects doing as part of maintenance. And that during our site visit conducted recently, that was also evident. So I think from our side, we'll then just support the tariff team in terms of sort of listing these. But yeah, there was definitely new assets added, and this also includes the tight lining assets because of Transnet's failure to commission TM1 tanks. So that also was another investment that each of the shippers had to do, including Engen, to enable us to proceed. So definitely there was new assets which came at fairly high cost due to it being fairly recent.
Okay, thank you. I take that you are done on this one. I just would like to emphasize on my side to say, when looking at these figures, have that as a standard line of saying is subject to audit and any prudence assessment that may be embarked upon by the energy regulator. Also, we highlight the issue, sometimes the matter that Madam Asset will refer to as a yellow card, that sometimes you've got you issue a yellow card in terms of informing licensees of non-compliance, and then you require them to correct that. And sometimes they then embark on a process which then becomes a botch process because it doesn't really yield any valid or acceptable or adequate application, then prolonging the period between the time of notifying of non-compliance with regard to the period for the validity of a tariff to when a new tariff is then approved. That is also part of the challenges, which I think, Mr. Untit, in enhancing the document, you need to cite that. And I heard you Madam Bogo highlighting the issue of verifying that the licenses are charging tariffs that are not exceeding the tariff approved by the energy regulator. I think you should also qualify that we need to shorten that period, because really, if you come way later after the period that the tariff was charged, it doesn't help much. So we need to shorten that period. Like maybe if you were to look at a period that is even a quarter preceding your time of considering that tariff implementation, that would actually be more helpful. So in enhancing the document, I think it's also clear that there are certain challenges that are there based on the practice thus far, as well as the legal provisions, but those also are being looked at in terms of improvement. Just to highlight that. Madam Aseti, I see that your hand is up. You may come in, ma'am.
Thank you very much, Chairperson. Chairperson, I do want to emphasize that the fact that here, since we are dealing with the tariff, it's a given thing that the team ought to have verified the values. It's not something that they must do after the fact, though. It is something that should have been part of their assessment, especially because they have taken so long to bring this this submission here, or this application before us for a decision. And the licensee applied in December 2024. Now we come at this time, and these are applications that we do all the time. In reality, we should not even be taking more than 4 months in finalizing these applications. But now they come and they still have not verified the values, but they see that there is excessive increase. Now they should have had, they should have included the specific assets that gave rise, or that gave rise to this increase, to have the list of the assets and go with the licensing colleagues to coordinate properly, and then have the nature of the assets that were added in the RAP for adjustments purposes. And in addition to that, make it clear to the licensee that we also need book values for these assets. I mean, here we're also talking about new assets. We're not talking about old assets where they would not have the book values of these assets. So these assets, we ought to have known, what are the values that we are talking about here in terms of the assets. That is the second thing. Now, the third thing that they should also have done is to then look into the accumulated depreciation. And now they're not helping us in understanding this. Now we must just approve, assuming that maybe later on they will do this, since I've also said that maybe they will need to, there's a need for that, for the audits to be done, and then do this work after the fact. Then they will be able to make some adjustments. But the accumulated depreciation from 2011, as we are using the same methodology, and it's not the other methodology that was used in 2016. So here we don't even know what is the accumulated depreciation, so that we can make an adjustment, and maybe that could even reduce the RAP even further. So they must do that exercise then of accumulated depreciation, even from the old assets, get the book values of the other assets that were added and then indicate clearly what adjustments in terms of values were then made in the RAP because of these additional or combined assets, plus newly constructed assets. So that is important, Chairperson, as they are gonna go ahead now, because we can't accept this as a RAP that we will start working on going forward, even for next year and the year after and so forth, until we get this right and do the corrections that need to be made and the valuation of the RAP. That is important, Chairperson. Otherwise, we can't go with these figures. For now, we'll approve, but subject to these things having been done, Chair. Thank you very much.
Thanks, Madam Maseti. Maybe for the record, I want to also indicate, if you go to table 5 in terms of the schedule for processing the application, you'll know that although the application was first submitted in 2024 after engagement of Engen, also appreciating that in companies like Engen and others, with all these challenges that they face in terms of the changes, they have had also a challenge in terms of the movement, staff turnovers, in terms of people that were handling these matters, bringing a challenge even to the energy regulator. You will see that on row 11, the application was actually declared adequate only in July, on the 10th of July 2025. Though it's got come a long way, taking more than 7 months really for the right information, all the information to be on the table of the regulator. And I think also of importance is like I would say to the team, if we have had such a long gap, only from the point of view, not only, but I'm saying especially from the point of view of optics, it's important, Madam Bog and your team, to also maybe even indicate an equivalent annual increase, from 2011 to 2025, so that we're able to see this in context, as if it's not a jump from the previous year to now. I think it's important to have that. And also to say that in terms of the figures, I'm talking here primarily with regard to the prudence assessment. Both in prudence assessment, you look at a host of other features based on the prudence guidelines that might result in some changes. Just to qualify that, so that in case we do something in future, it's not seen as if we are going back with regard to the decision we're taken, because that should be a standard line. And I take it that the other matters are taken care of. And Madam Bogo, if you may just respond so you can just bring the matter to the close.
Chair, I just want to give members comfort that the asset values that are included into the RAB are backed up by the asset registers. So we have a whole list of the assets, their useful lives, and then that would be then what we use to apply the trended original cost valuation methodology. So we have not we have based it on the regulatory asset base. The only thing that has not been done, we verified the cost. We verified that the licensee actually incurred the cost. The only thing that has not been done is then assessment of prudency of the costs, especially for the new assets. Otherwise, all what we see in that PP in the regulatory asset base is based on the asset register we got from the licensee, and we have to the best of our ability verified the costs and verified that the costs were actually indeed incurred by the licensee to date. We also have that long list. It's just that the document is too big. We wanted to email it so that members have sight of the work that went into the verifications of the asset base. Thanks.
Thank you. Maybe in closing, also from my side, I just want to say that I in guiding the team to say, please make sure that you encourage licensees to have multi-year tariffs, so you don't get into this kind of problems. And also, I think it's going to be important for you, Madam Bogo, and the team to engage Engen to make sure that they then submit the subsequent tariff application soonest, noting that we only have got about how many months? 13 months. Yes, 13 months that are left in terms of the period for this tariff, which means that for 27, 28, 29, they need to submit an application, to lodge an application with us soonest. Please note that. Having said that, members, if there are any other question, and if you are covered with the questions you have posed, may I then proceed to the recommendations, which are on page 14 of 39, under paragraph 14, which reads thus: it is recommended that the PPS approves the tariffs applied for by Engen for its petroleum storage facility in Island View for the period 1 January 2025 to 31 December 2026, provided in Table 10 below. And Table 10 reads thus: the tariff for 2025 is 24.53 cents per liter, and for 2026 is 24.50 cents per liter. The PPS is also requested to approve the decision and reasons for decision document attached here to as Annexure A, subject to the enhancements based on the inputs and guidance provided by members in this meeting. If you support the recommendation as read out, please raise your hand, members. Thank you, Madam Pumose. Thank you, Advocate Tole. Thank you, Mr. Sbanda. Thank you, Madam Maseti. I also support. This then concludes item 5 and takes us to item 6, which is a discussion document on the guidelines on tariff differentiation features acceptable to NERSA. Over to you, Mr.
Thank you.
Umtiti.
Thank you, Chair. Mr. Koli Mslangu will be introducing it. Also noting there is 2 documents, I think there are 2 documents uploaded on Convene. Just to clarify, and he can confirm, the only difference there is the second document was done, a language editing was done, and then subsequently uploaded. But Mr. Mslangu, the key elements to highlight to the members.
Thank you, Martin. Thank you, Chair. Good morning, members, management, staff, and members of the public. Section 21 of the Act prohibits discrimination between customers or classes of customers regarding access, tariffs, conditions of service, except for objectively justifiable and identifiable grounds approved by the authority, close quotation. However, the Act and the regulations do not prescribe or provide the specific, objectively justifiable and identifiable grounds under which licenses may differentiate. The Act merely provides that NERSA should approve such grounds. This omission has resulted in a regulatory gap regarding what constitutes acceptable and objective grounds for tariff differentiation. In performing its duty under Section 28(4) of the Act, which is to monitor the application of tariffs and ensuring that tariffs are applied in a non-discriminatory manner, NERSA has observed, amongst others, that licenses generally do not apply for prior approval of the differentiation features used in implementing tariffs. Secondly, some licenses have in practice charged different tariffs to third parties or classes of third parties without objectively justifiable and identifiable grounds approved by the energy regulator, thereby contravening Section 21 of the Act. To rectify this regulatory gap, the guidelines aim to clarify the legislative and regulatory requirements about tariff differentiation, provide the differentiation features which are acceptable to NERSA, identify and communicate the process of approval of such differentiation features, and promote consistency, transparency, and fairness in the application of differentiation tariffs across the petroleum pipelines industry. It is therefore recommended that the PPS knows the discussion document on the guidelines on tariff differentiation acceptable to NERSA attached here to as Annexure A of the PPS submission and approves the publication of the discussion document on guidelines on tariff differentiation features acceptable to NERSA. Thank you, Chair.
Thank you very much, Mr. Mahlangu. Siyathokoza. Members, any questions, comments, guidance from your side by show of hands, please? Madam Maseti, then Mr. Sbanda. Over to you, ma'am.
Thank you, Chairperson, and thank you to Mr. Mahlangu. Chairperson, I just want to understand, and this is just for enhancements and to stick to the language of the Act. And also this could affect our powers for the differentiation factors. So the Act, Chair, I think it's got because I'm raising this because in other legislation that is administered by NERSA, these things are separated. In the Gas Act, for instance, there are specific objectively identifiable differences. And then the next part of the section will then say, for those that are not prescribed, NERSA will have to approve. But in the PPA, it doesn't prescribe those objective differences, although it says in the Act it will be the objective and identifiable differences. So is there a reason why, firstly, that we put these as guidelines as opposed to putting them as the objective and identifiable differences or factors that NERSA would consider? The reason I'm concerned about the guidelines is because guidelines are not binding. So they might, licensees might choose not to necessarily follow what NERSA has viewed as identifiable and objective. So we must really have some few that are objective ones. Then others will then be things that are happening in the industry because the market is dynamic, and therefore it will be certain features that people will come up with. So the aim here for me is to at least have the category of those factors that we know they are objective, we can prove them, they are quite objective, and we can actually see them. Objective and identifiable. And then we can have other factors or features that may well be applicable in this industry, even though they're not necessarily objective and so forth, but you will do them for purposes of encouraging efficiencies, for instance, and for purposes of encouraging the official usage or utilization of the pipeline and so forth. So those could just be some of the features. I'm just giving an example because those are not necessarily the objective differences between the classes of customers or classes or individual customers. So they would not fall under the objective ones. So that's the categorization that I am envisaging, and I was asking if we should not have those categories of them and stick to the language of the Act in terms of the identifiable and objective ones. Then say these are the factors for that, and then the others may well be the forward-looking, encouraging investment, encouraging utilization that is efficient and so forth. Then you have them as the features approved by NERSA, even if they are in the same document. Then the other one as to why do we choose to have them under guidelines when guidelines are non-binding. I am saying this because it has been a challenge for also gas when you come, the parties and their lawyers to say that, well, even if you have it as a tariff and you are allowed in terms of the Act to approve the tariff, however, because these are guidelines, it's not something that is binding to us. So we may well choose, another method that is suitable for us. So how do we deal with that aspect if the Act says they must only use what NERSA has approved, and then the fact that guidelines are not binding? Thank you, Chair.
Oh, thank you, Madam Aseti. Sorry, I was on a muted mic. Thank you very much, Madam Aseti. I think maybe before I get to you, Mr. Subanda, let me read out Section 21 of the Petroleum Pipelines Act, number 6 of 2003. It reads thus: licenses may not discriminate between customers or classes of customers regarding access, tariffs, conditions, or service, except for objectively justifiable and identifiable grounds approved by the authority. The authority in this case is the National Energy Regulator of South Africa. Just wanted to read them out. And then Mr. Sibanda, over to you, sir.
Yeah, Chair, maybe based on that, then we need to then clarify that licensees will still need to apply and the authority will still need to approve those objectively, what does it say? Objectively justifiable and identifiable grounds. And that the guidelines are just meant to guide, but licensees will still need to apply, and that will still need to approve. Maybe if you can clarify that, if my understanding is correct, Chair, based on what Ms. Masetti has raised. But from my side, I just have a couple of comments. And again, depending on how the team responds to the comments by Ms. Masetti, I'll probably just go page by page, Chair. I'll try to be quick. Starting from page 4 of 15, the list of comparative approaches. Look, I mean, I'll probably leave ITEC out of this and just deal with infrastructure regulators only here, Chair. Excuse me, and just leave ITEC out of the list. And then on page 6, I'm not too sure that the discussion around the Competition Act really belongs here, Chair, in this particular section. I'm talking to paragraph 2.3, the whole of it, 2.31, that whole discussion around the Competition Act. Apologies for the background noise, Chair. There's just some excitement going on here. But I'll remove that portion, because if you, then it will flow from 2.2 to 2.4. And that discussion around the Competition Act then belongs to the rest of the other discussions on whether you want to call it benchmarking or whatever it is, but that list of regulators where you then talk about their approaches. Then the next issue for me on page 9, so we then talk about the approaches to differentiation, and we then mentioned tariff-based differentiation. I suppose we wanted to say volume-based, because it can't be a tariff-based differentiation, because that's what we're talking about. So there must be something that then results in the differentiation. It can't be the tariff itself. So the tariff is the resultant outcome. So I'm assuming this probably wanted to say volume-based. And then regarding risk-based differentiation, we just need to be careful here, because assessing a risk profile of a customer can be very subjective. And we see this in many industries, whether it's credit or insurance or whatever. Risk assessment can be very subjective if practiced by a supplier to a customer. So I'm just saying that it's just a caution that if we were to perhaps assess an application that comes to us and cites a risk-based differentiation as a reason, we just need to be very cautious how we apply that, because this can be subjective. And the Act talks of objectively identifiable reasons. The next one, I just could not wrap my head around. This is on page 11. The difference between international versus local third parties. I probably just need an example here. Why would you want to differentiate or discriminate between international and local third parties? And we mentioned things like, global supply dynamics and exchange rate variations and the like. I'm not too sure if those are really, could be grounds, but maybe I need an example to try and understand those. And then the next comment is on page 12, where we talk about unacceptable justifications. And one of those is market dominance or bargaining power of the licensee. And my question is, have we considered the bargaining power of the buyer, what is referred to as monopsony? Because if I'm a customer and I've got bargaining power, I could negotiate a lower deal compared to my competitors, and will that be justifiable? So I'm just posing a question that says, have we looked at the bargaining power of the buyer or monopsony, or we're just looking at it from the licensee's perspective, or the supplier's perspective, or the monopolist perspective? And then I think those are all my questions and comments, Chair. Thank you.
Thank you very much, Mrs. Banda. Tim, may you please respond?
Right. Thank you, Chairperson. Sorry for that. Chair, the first one is a little bit tricky for us. Maybe the committee will then direct us as to whether this should just be objectively justifiable and identified grounds that are acceptable to NESA, or whether they should which they should remain guidelines. I'm amicable to the change, but then we'll take guidance on that one, Chair. Sorry for that. And then a lot of Mr. Sibanda's comments are guidance, which we are accepting and thankful for. And then what I wanted to maybe come in to clarify is with regards to the risk-based differentiation. So we were hoping there, Chairperson, that any licensee who differentiates based on the risk of the customer would then be able to prove the risk and then submit proof thereof, if it is used as a basis for differentiation. However, maybe we could make it add a question to that effect, so that we get input from stakeholders and decide thereafter. And Mr. Sibanda then also asked for an example of the difference between local and international parties. Chair, we have instances where licensees with regulated facilities at coastal land, especially in Saldanha, who are serving customers that are within the South African land and outside of the South African land, who had tariffs that were dollar-based. So the approved tariff is based on dollars. And then when we do the audit, we found that if you then convert to rands for purposes of comparing the tariffs that are charged to various third parties, then there is a slight difference, or there is difference mainly driven by this dollar denominated tariff. So this is why we then ended up to having that as a differentiation feature that could be acceptable to NESA. And also, we from practice experienced that some of those customers, especially in Saldanha, are not specifically in the business of selling or selling petroleum products, but then some of them are traders who are buying crude oil when it's cheaper and then keep it and sell it when the prices are high. So they're solely in the trading business, and they are international third parties. So there has been instances where the parties there or the licensees in Saldanha differentiated on that basis. So that we wanted to also accommodate that. And then the last comment from Mr. Sibanda is something that we will include, and where we include this bargaining power of customers, especially because this is something that we experienced for one of Transnet's storage facility in Tarleton, where we suspected this had happened. So we'll also include it in the unacceptable basis. I hope that suffices, Chairperson. Everything else we take as guidance. Thanks.
Thank you. I think when it comes to the risk-based differentiation, which can be very subjective, we need to maybe include a question that maybe specifically looking at that to say what is the view around this being abused, because it could be abused to bar new entrants, sometimes profiling prospective clients, and then you then kind of amounts to discriminating against new entrants or triple BEs. I think we need to be able to check that. And members, I would like you, when maybe if you want to just a last round of comments, if you have the view that we should not have guidelines, because I was looking at it that if we have got guidelines, it means that the licensee must then obtain the regulatory approval for those objectively justifiable and identifiable grounds for differentiation. So if we go that route, and that will also require the internal processes to be streamlined, to be able to get that approval soonest, so that there are no delays, which means that if we look at the delegation matrix, such could be dealt with by way of, for example, the instruction, and then that instruction, then there would be quarterly or so or regular reports to the committee in terms of such execution of such instruction. That would be my take, and say that at this juncture, to rush into being very prescriptive could prove problematic because of the fluid nature of the industry, and how what worked yesterday could prove not good the next day. So these are some of the things that I'm looking at, and I'm thinking if we keep it as a guideline, like we did with the prudence guidelines, and then we still then are able to check if the costs have been incurred prudently. So that is a consideration, members, from your side. I see Madam Masati's hand is up. If you may just chip in, ma'am.
Thank you, Chairperson. Chairperson, I provided guidance. I see that it has not been taken into consideration. And my guidance is based on the fact that we also tried before to come up with a document that will assist the industry. But let me be specific here. First of all, the section of the Act that we want to give effect to is very specific. It says that we must consider objectively justifiable, but what we have in the document is not always, it's not things or factors that are objective. Some of them are very much subjective. So that is a first red flag. So the Act says we must consider objectively justifiable and identifiable grounds. The only difference in terms of the Gas Act is the differences, but it's still the same in terms of what are the objective, objective as well as identifiable differences between this customer and that customer, or between these classes of customer and that other class of customer. So we need to, first of all, have the objectively and identifiable grounds. So let's separate those matters that are subjective. In terms of differentiation within prices or tariffs, there are very much established differences, and they are based on commercial as well as economic grounds. So can we be very clear that, first of all, for objective, we know it's not something that we can just think about it from our side and say this is what could go there. It is something that is already established. So where something is already established, we need not go around about it. So let's deal with it. And it happens everywhere. It's not only here in NERSA. Everywhere, regulators that are sector regulators, and whether it's actually competition authorities, there are factors when we deal with differentiation. There are factors that are objective as well as identifiable. So let's deal with that and package them differently. And then on those ones, we will be specific, Chairperson, because the Act says they must be objective and they must be identifiable. Then we can have another category, understanding that the market is dynamic, and I used that term. And as you say, Chairperson, that it is fluid and there's a lot of other changes. Then we can have that as some of the distinguishable features or differentiated features. So those are now features of the market. And maybe these features of the market may justify that maybe under these circumstances, we would then try to understand and allow some differentiation of some sort. Then that shows a dynamic and forward-looking approach by the regulator, understanding that there could be changes in the market. But those now, you can't say they are objective. They will be subjective. They will need certain reasons and the understanding of the sector. And then you come up with those as a separate category. So that's what I'm suggesting, because even now, listening to the colleagues, if we as the regulator ourselves, we try to use features, the features is very different. It's the market features, what's happening there in the market, certain things that are happening. But here we are not given that mandate. Our mandate is the objectively justifiable and identifiable grounds. So I would suggest that those will be separated, the objective from the subjective. And then we can ask them to then keep on bringing those differentiated features. If we want to add those, they must bring them to the energy regulator for approval. That will still be fine. So in terms of the objectively justifiable and identifiable grounds, I see that the document does make mention of the cost, and we can't go wrong there. That one is commercially as well as economic justified in terms of the cost differences. In terms of the volumes, again, it's another objective ground, the volumes. The other objective ground is, which I'm not sure to what extent it's applicable in the petroleum pipelines, the duration of contract. So that also is a difference. Then the other difference is what is it? Is difference is the distance of the customer from the point of supply by the pipeline. I know that in the Gas Act will say that it is the transmission distance. So how far are you from the from where the pipeline starts and so forth? So that becomes also the identifiable, because it's the distance. How far are you from the point of the pipeline and so forth? Then I don't know if interruptible supply is applicable here, but in gas and electricity, it is applicable. Hence, we have the NPAs in electricity, and also in gas, if there is a customer that say you can interrupt us at the particular point, and therefore you share the cost and so forth, and the way that it happens in electricity. And then we also have that in gas in terms of interruptible. So I'm just giving examples of those that are objective. And then also contract, the duration of the contract. And I know this also, it goes to the competition authorities, and they even came up with some of those objective differences. Always the duration of the contract becomes the difference. And even not just here, I think it comes to the issue of whether these transactions are equivalent transactions. And that is not something that is only applicable in South Africa. It's applicable in other jurisdictions as well. Whether you go to the EU and whether you go to the US, there will always be that issue of differentiation between equivalent transactions, and some of those are issues of the duration of contract. I was just giving an example, but this is the subject matter that is close to my heart, and yeah, I know that I've also done my dissertation in this area, and yeah, and it is an area that I've done a lot of work in, even at the competition authorities. Thank you very much.
Thank you, Madam Massetti. I don't think we're doing well now in terms of time. I would like us to move towards a decision on this one. But just to emphasize that on when it comes to service-based differentiation, the latter mentioning, if you look at on page 18 of 24, the service base actually captures the issues that you have mentioned of interoperability and other conditions of service that could be applicable, including the duration of let's say you're storing that particular product. And then the risk-based one will be those that fall into that category that is subjective. Because if you look at the Act also is not necessarily talking to those that are objective and subjective, but it's talking to objectively justifiable. Even if something is subjective on someone else's point of view, but we need to then look at that subjectivity. If it is based on, it is still objectively justifiable and identifiable. Because if some people are more risky, you need to be able to justify how that risk comes about and how it affects your operations and your profitability, or it's got any commercial impact, and that commercial impact then translates into a different tariff for that particular individual. I take it that at the moment, when we're on a stance of guidelines, I think a team maybe also consider looking at how more prescriptive we need to be, include a question to say if they are of the view that this must be kept as open guideline, or we must be more prescriptive, especially around those that are deemed to be objective without not needing a lot of work. For example, the cost, the issues of volumes or quantity or duration of contract, because even if it is, one could end up with a situation where something is justifiable, but the quantum is not justifiable and could be discriminatory. If they say the smaller BEs are bringing in small quantities, they are coming up with small cargoes and they are charged more, and the quantum of the difference does not justify the differential. That also could be problematic. I would still say that as this sector, we are starting with this. To start on a more cautious stance would be better, the best foot forward. And if the comments we get are to the contrary, then one would then have to really reconsider, because one is sending these things, would be sending these out genuinely seeking for inputs and improvement instead of being headstrong and trying to push a particular position with no regard of the comments that we're getting. So with those enhancements, and also just to highlight and incorporate the issues that have been put forth regarding what these things that appear very clearly more objective and the others being subjective. If you may just improve the document in that regard, Madam Bogo and the team, and before you issue it out for public comments. I would like then members to take you to the recommendation, which is on page 8. It starts from page 7, goes to page 8, which is the recommendation that the PPS notes the discussion documents on the guidelines on tariff differentiation acceptable to NERSA attached here to as Annex A, and approves the publication of the discussion document on guidelines on tariff differentiation features acceptable to NERSA. By show of hands, if you approve of this recommendation. Thank you, Mr. Sibanda. Thank you, Madam Maseti. Advocate Tole. Advocate Tole, Madam Pungose. I don't see your hands. Oh, thank you, Advocate Tole. I've just been I noted that Madam Pungose would just step out to tackle something and come back. I'm in support, so then we proceed on that basis. Thank you. We then go to item 7, which is the review and propose amendments to the Petroleum Pipelines Rules 2019 to be published for stakeholder comment. Over to you, Madam Bogo and the team. Mr. Martin?
I think, yeah, the review and the draft amendment will be led by Ms. Magamata, which will highlight the salient items.
Thank you, Mr. Unted, and good morning, Chair and members of the committee and everyone on the call. Chair, this submission relates to the draft amendment of the Petroleum Pipelines Act rules, which are made in terms of Section 33, subsection 3. The submission to seek and to note the proposals that have been put forth and then approve the publishing of the draft rules for public comment. The amendments that have been put forward, Chair, are part of PPR's ongoing commitment to enhance our efficiencies, to ensure legal compliance with our legislation, and also align with other departments and divisions within NERSA. The key proposals, the key proposed amendments include, firstly, the reverting of the definition of days from working days to calendar days, which is in line with the Interpretation Act. And this is mainly to improve our turnaround times, particularly in terms of processing of applications, but also to ensure alignment with the other regulatory divisions and the public hearing rules as well, so that there's no confusion in terms of interpretation of days. And then the second element is the introduction of an application fee, which is also required as in terms of section 16, subsection 1 of the Act, which states that all applications must be accompanied by an application fee. So here, the introduction of this in the rules is really also to ensure we are at full compliance with the legislation provisions. And then the third element talks to clarifying the responsibility for the advertising of amendment and revocation applications. So basically shifting this obligation to applicants and thereby reducing costs to NESA. So historically and to date, the applicants for new license applications incur the cost of placing a notice in the newspapers, informing public and stakeholders on the fact that they've lodged an application. However, for the amendments and revocation applications, that responsibility by practice is being handled by us as NESA. And this is simply because we had not prescribed it in the rules. And then we have also introduced the definition of conversion, which is mainly to provide clarity on the licensing of previously non-regulated facilities that are transitioning into regulated petroleum use as per our mandate. And then, Chair, lastly, we have also put proposals to enhance provisions relating to initials by NESA, patients. We've also expanded the complaints and investigations as well to ensure alignment with the other NESA regulated sectors. So, Chair, the proposed amendments collectively aim to really streamline our processes, reduce timelines, and reinforce consistency as well. I therefore recommend that the subcommittee notes the proposed changes and approves the publication of the draft rules for public comment. Thank you, Chair.
Thank you very much, Madam Makamata. I want to repeat, members, the issue of our primary legislation being long in operation in the face of a changing industry, having it remaining the same when us only in the main left with dealing with regulations and methodologies that we're using and other mechanisms, which still remains a challenge. We hope that there will be changes in the near future to the primary legislation to enable us to handle some of these things better. But it is what it is. And leaving to you, members, if you've got any comments or questions or any guidance to the team to enhance the document prior to it being released for stakeholder comment. Over to you then, by show of hands, please. I don't see any. Oh, I see one hand from Advocate Tolle. Over to you, Madam CEO.
Thank you, Chairperson. Chair, I think I've got two contributions to make. One is that let's not only mention section 16.1 of the PPA in terms of the fee that needs to be paid for license application, because NERA as well, in terms of section 12, does allow the regulator to charge license fees. So I just thought that we could do that as a point of enhancement. And secondly, Chairperson, in the submission, I think in one of the pages, it's mentioned that the 400 license application was approved by the energy regulator, but there is no indication as to which meeting because I think for me it was important to make reference and just get the background as to what was the basis for that. I may have not been part of the ER at that time, but I wanted to know what was the basis, because in the submission there's no indication of the basis for the license fee of 400. And maybe the team can explain that, because if you continue to read the submission, it's also indicated that, or there is an implied indication that the 400 may not be sufficient. And I also support that particular view, because I don't believe it's sufficient. And I wanted to check as to the 400 that is being proposed. Was it benchmarked? And what was the benchmark outcome? So, Chair, the last one is just a point for clarity from the team to just explain the basis for the 400 that needs to be charged. Because if one looks at other regulators, especially within the SADC region, they don't charge this little amount. And I don't think it is going to be sufficient, especially when we consider the fact that in terms of our budgeting process or our financial strategy in terms of getting resources as a regulator, it's declining. And one of them was just to have licensed fees charged. But if we do not have a proper backup as to the basis of what we are proposing, it may be a problem. And from my side, I believe the proposed 400 rand application fee may not be adequate to even cover a part of our operational requirements. Thank you, Chair. I'll stop there.
Thank you very much, Madam CEO. I think on what you're talking to is pertains to paragraph 4.15. And then
and 4.17, Chairperson. Thank you.
We are 4.15 to 4.17. And I think that if you can just include the date on which the meeting was held approving this 400 rand, because it's no longer a proposal, but it's approved. And therefore, if you can just include that to enhance, and also you can make some changes to the last sentence of 4.17, where like the reference to the Petroleum Pipelines Act to make the letters in capital, these first letters there, amongst other things, just to put that application fee and indicating that it be done via a different process in terms of looking at that. Also at the same time, let's just be careful not to get this hindering or delaying this process, but inputs in therein would also assist. But over to you, Madam, Mr. Untit and your team.
Yeah, thank you, Chair. We thank you for the enhancements, and we will incorporate them specifically nearer section 12 as indicated. Also your guidance, Chair, in terms of that. Then, yeah, sorry for the omission, CEO. The date of the ER meeting we will include. It was 2 financial years ago. It was based at that time, it was benchmarked, and in that submission. So I think maybe the oversight years that we should have also afforded the members with that document in the reading room to give you the context. It was benchmarked with 102. You correct that the subsequently and with also the change of amendments and revocations becoming the majority of our applications, and it consuming the same resources linked to the project that the sustainability of NASA, we have engaged with the CFO on this. So the quantum now was to give you the context. We will supply with that information. The only advice we got from legal was that we need to first amend the rules to be able to charge, but the quantum will not be included in the rules. That will be dealt with separately. But yeah, we take the guidance, Chair and members, and we will share the things. I'm not sure if I need to give more comfort to the CEO, but it was benchmarked. It was based on primarily the license management coordinator, but I think we have since realized that that is not sufficient and doesn't cover it adequately. Therefore, as I said, we are working with the CFO also on this aspect. But for now, the quantum will not be prescribed in the actual rules, just that there will be such a fee. I trust I've covered it, and we will do the enhancements accordingly, Chair and members.
Yeah, thank you. Thank you, Mr. Untit, because if you look at the whole exercise was done on a different premise, which needs to be revisited. I think the same applies to registration fee for electricity projects. But thanks for the response. This then, CEO, if you are happy with the response, we'll then proceed to the recommendation. The recommendation is on page 9.
Chair, I'm happy with the response as long as the quantum are going to be separated. But what we shouldn't miss is to have them dealt with within the process of the sustainability strategy, financial sustainability strategy of NESA. And I do know that Ms. Mtwa was involved with the CEO in terms of approaching National Treasury. So if we agree on that, I do support what is before the subcommittee today. Thank you, Chair.
Thank you very much, Advocate Tole. This then takes me to the recommendations, which are on page 9 of 97, paragraph 14.1, which reads thus: it is recommended that the Petroleum Pipeline Subcommittee notes the attached draft rules made in terms of Section 33, Subsection 3 of the Petroleum Pipelines Act 2003, Act number 60 of 2003, the Petroleum Pipelines Act, and a summary of the proposals attached here to as Annexure A, and approves the publication of the proposed draft rules attached here to as Annexure B for public comment. By show of hands, members, if you do support the recommendation. Thank you, Advocate Tole. Thank you, Mr. Sibanda. Thank you, Madam Maseti. I also support. Well, let me when Madam Pongos is back, but we proceed on that basis of item 7 also being approved. We note that when it comes to the items that must be dealt with in the open meeting, we've come to the end of this meeting. I would like to take this opportunity to thank you, members, for your invaluable insights, your comments, guidance you provide, as well as the questions posed, which help in terms of ensuring that this portion of the regulator becomes more and more effective and efficient in terms of regulating the petroleum pipelines industry. That is very much appreciated. We appreciate also the work that is put in by the management and team, as well as the support functions that are linked, because it's not about PPR. I think it's about the whole staff of NERSA that works together to make sure that the work of the regulator actually is beneficial to the industry and to South Africa in cooperation. I would also like to thank the members of the public, because just by mere following us through the various live streaming platforms, you push us to do better every day. That is appreciated. And your comments on how we're doing our work will always be appreciated, because we do believe that we don't have the monopoly of wisdom in dealing with these issues, and we need to be advised from time to time. We appreciate everything, and then this brings us to the end of the open part of the meeting. I also want to appreciate IT for assisting us in terms of linking with the rest of the world.